how does a democracy subtly, almost imperceptibly, begin to shift from its established norms? What are the earliest, sometimes subtle, but profoundly important indicators that signal a deeper change in governance? We're exploring that critical point where the very mechanisms designed to ensure public safety, the police, the military, our security forces, are directed inward.
Right.
Not against an external threat, but against segments of its own population. This dynamic and how it unfolds presents a complex analytical challenge.
It truly does. And it prompts us to ask a crucial question. What does this process look like in practice, particularly when it's presented under the guise of, well, legitimate public safety measures?
Yeah.
Understanding the specific mechanisms by which such a transformation might occur is essential for anyone analyzing political systems.
Precisely. And that's our mission today. We embark on a deep dive into insights from a new analysis: the coercive state, policing, and domestic control. Our objective for you, our listener, is to unpack the intricate mechanisms and broader implications of how a domestic coercive apparatus,
which includes quite a range, right? Police, National Guard.
Exactly. Police forces, National Guard units, active duty troops, even immigration enforcers, how this whole apparatus can become a prominent feature in discussions of democratic erosion. We're not just exploring theory, we're examining how these dynamics manifest in real-world scenarios.
Our central inquiry for this deep dive is to consider how and when these coercive tools, typically associated with national security, might be wielded in ways that critics argue target a government's political opponents or marginalized groups.
Right.
This raises a fundamental question about the integrity of democratic principles. We'll be tracing this through a series of interconnected events and policy shifts, examining the patterns that emerge.
Okay, let's begin to analyze this. We'll start by dissecting two immediate situations from 2025: the federal deployments in Los Angeles and the significant federal intervention in local policing in Washington, D.C.
Two key flashpoints.
Yes. From there, we'll navigate the complex legal battles that ensued, examining critical statutes like the Posse Comitatus Act. Then we'll move to the systemic expansion of this domestic enforcement machinery, looking at new legislation, massive detention capacity increases, and significant policy shifts.
And putting it in context is important too, right? Comparing it.
Definitely.
Yeah.
We'll place these American developments into a comparative context, drawing parallels with El Salvador's state of exception and historical U.S. cases like COINTELPRO and the 1968 Chicago Democratic National Convention.
COINTELPRO, yeah.
Finally, we'll confront the critical question: at what point might rhetoric about law and order and public safety evolve into a framework primarily supporting government preservation? You'll get a richer understanding of these dynamics and a robust framework for critical assessment.
The central argument we'll explore is that when these coercive tools are wielded specifically against a government's political opponents or marginalized groups, it signals a profound erosion of democratic principles. That's the core thesis.
Let's jump right into these initial situations then, starting on the West Coast, specifically Los Angeles in June 2025. This situation provides a striking example of federal action in a local context.
It really does.
The series of events that ignited the unrest there began with sweeping raids conducted by Federal Immigration and Customs Enforcement, or ICE, agents. These operations were not limited to border areas, they were conducted deep within communities. Can you detail exactly what initiated this particular unrest?
Certainly. These were not isolated incidents, but rather extensive, highly visible raids conducted by ICE agents targeting specific locations within the Los Angeles metropolitan area.
Like where, specifically?
Well, these targets included places where day laborers typically gather, such as Home Depot parking lots, which serve as vital community hubs.
Okay.
Operations also extended to a garment factory and a warehouse, suggesting a deliberate strategy to impact specific economic sectors where immigrant labor is, prevalent.
In a result.
The immediate consequence of these actions was significant. At least 44 individuals were arrested for immigration violations. This represented a clear demonstration of federal authority being exercised domestically, directly impacting civilian populations.
And how did the local community, and indeed the broader public, respond to these specific targeted raids? What was the immediate local reaction?
The local response was immediate and notably intense. Protesters mobilized quickly, and their strong sentiments were evident.
I remember seeing some images.
Yes, many demonstrators were observed waving Mexican flags, an act that symbolized their solidarity with the targeted immigrant communities and their perception of these actions as an intrusion on their identity and belonging. Their chants were direct and unambiguous. IC out of LA.
Wow.
This was not merely general dissent. It represented a strong reaction to what many participants described as kidnappings of community members, a term reflecting a profound sense of violation and fear within these communities.
Kidnappings, that's strong language.
It is. They viewed these actions not as routine law enforcement, but as an aggressive, unwelcome intervention into their homes and workplaces, impacting community cohesion and causing considerable distress.
So, given this intense local response and calls for restraint, how did the executive branch react? Did the administration pursue de-escalation?
On the contrary, rather than seeking de-escalation, President Donald Trump escalated the situation with significant and what many observers called controversial actions. He invoked what were described as extraordinary emergency powers.
Okay, how so?
On June 7th, he took the notable step of federalizing California's National Guard. This is a critical distinction, as it explicitly removed control of the Guard from the state, effectively bypassing Governor Gavin Newsom, a Democrat, and placing the Guard under direct federal command.
Federalizing the Guard. And the scale of this deployment, it wasn't just a small contingent, was it?
No, it involved a substantial force. President Trump deployed 4,000 Guard troops to Los Angeles.
1,000.
Furthermore, this was augmented by 700 active-duty U.S. Marines dispatched directly from Camp Pendleton.
Marines. Active-duty Marines on U.S. soil for domestic issues.
Yes. The inclusion of active-duty military personnel, particularly the Marines, in a domestic policing scenario, is considered by many legal scholars to be a significant deviation from long-standing American legal and democratic norms concerning military involvement in civilian affairs.
And this was done against the governor's wishes.
Explicitly against them. What further drew scrutiny was that this entire domestic military deployment was made against the explicit wishes of California's Democratic governor, Gavin Newsom, and specifically without the usual legal requirements for coordination with state authorities. Many analysts pointed to this unilateral action as a key indicator of a strong assertion of executive authority.
That's a significant point. Normally, it's the governor who commands the state's National Guard. So if I'm conceptualizing this correctly, the traditional chain of command, which typically flows from the governor down to the state National Guard, was effectively circumvented.
Completely severed, yes.
Instead, that chain was directly linked to the president, bypassing traditional state authority. It's like a direct executive bypass of established federal-state relationships.
That's an accurate verbal diagram of the situation. It distinctly illustrates a shift in how federal power was being asserted, suggesting a move toward greater centralization of control.
Now, what was the official justification offered for such a significant intervention? And how did that justification align with the actual situation on the ground?
Well, the stated justification from the White House was to quell what they termed riots and to protect federal facilities.
Riots and protecting facilities, okay.
Senior White House aide Stephen Miller publicly characterized the anti-IC protests as a violent insurrection.
Insurrection, that's a very specific legal term.
It is. Vice President J.D. Vance reinforced this narrative, publicly accusing insurrectionists carrying foreign flags of attacking immigration officers. This represented strong and, some argued, inflammatory language used to frame the situation.
Yet, it seems there was a notable discrepancy in their actions. If it was truly an insurrection, wouldn't a specific legal mechanism typically be invoked, like the Insurrection Act?
That's a key observation. Despite the strong rhetoric of insurrection, the administration notably did not invoke the Insurrection Act of 1807. This act would have explicitly authorized the use of military force against civil unrest or rebellion. Their omission of this crucial legal step was interpreted by many legal scholars as an implicit acknowledgement that the situation on the ground, despite the administration's public narrative, likely did not meet the legal threshold for an actual rebellion that would formally justify such military intervention.
Interesting.
This subtle but significant legal nuance is vital for understanding the administration's calculations and the broader legal context.
And the intelligence assessments, did they corroborate the idea of a violent insurrection? Was federal property really at risk?
On the contrary. Crucially, later court proceedings revealed testimony from a U.S. Army general who possessed direct knowledge of the operations. This general testified that intelligence assessments showed little threat to federal property or personnel during at least one planned ICE operation in Los Angeles.
Little threat. So the intel didn't match the rhetoric.
It presented a stark contrast to the administration's public narrative of widespread danger and violent insurrection. Governor Newsom himself characterized these moves as purposefully inflammatory.
Inflammatory.
He argued that there was no shortage of local law enforcement capacity to handle the situation adequately. Newsom contended that the federal government's motivation was primarily to create a spectacle.
A spectacle.
He stated quite directly, and I quote, "It's deranged behavior to threaten deploying active duty Marines on American soil against our own citizens." This, quote, powerfully encapsulates the state's perspective on the perceived federal overreach.
Okay, let's take a moment here about 5 minutes in to crystallize what we've just discussed. This is our first micro recap. We've laid out the core elements of the Los Angeles situation. How federal forces, including active duty Marines, were deployed despite the explicit objections of local authorities.
Right, against the governor's wishes.
This was justified using powerful rhetoric of insurrection. Yet that rhetoric appeared to be contradicted by internal intelligence assessments and the administration's own omission of relevant legal acts, like the Insurrection Act.
Which is telling.
The evidence suggests these deployments were driven by considerations beyond immediate public safety needs, perhaps to create a political display. This sets the stage for a critical analysis of federal authority and the underlying motivations behind such actions.
And this West Coast scenario was not an isolated event, a point that is crucial for understanding the larger pattern. Simultaneously, on the East Coast, Washington, D.C. became the setting for another, arguably even more significant, assertion of presidential authority in August 2025.
What exactly transpired there? D.C. is unique, not being a state?
Exactly. On August 11, 2025, President Trump announced the deployment of 800 National Guard troops to D.C. That part is less unusual given the president's command over the D.C. Guard. However, what was truly notable, and indeed unprecedented in modern times, was his declaration of a unilateral takeover of the D.C. Metropolitan Police Department.
A takeover of the local police?
Yes. An executive declaration asserting direct federal control over a major city's local law enforcement.
So this effectively bypassed the city's elected leadership, Mayor Bowser and the council. That seems to represent a significant challenge to local autonomy.
It was an explicit bypass of the city's elected leadership, D.C.'s mayor and council. This action marked what many described as an extraordinary assertion of presidential power in the nation's capital, with very few, if any, modern precedents.
Yeah.
Typically, municipal police forces operate under local civilian control and accountability. This action represented a direct federal assumption of control over those local structures.
And what was the presidential justification for this D.C. takeover? Did the crime statistics, as he claimed, actually support this narrative? Because I recall hearing conflicting reports.
Well, President Trump insisted the takeover was needed to rescue Washington from a wave of lawlessness, painting a dramatic and alarming picture of a city overtaken by violent gangs and bloodthirsty criminals. That was the public narrative.
Yet, the data seems to tell a very different story, doesn't it? This discrepancy raises an important analytical point.
It absolutely does. Crime statistics for D.C. at the time of the takeover presented a very different story that directly challenged the president's claims.
How so?
While D.C. had experienced a spike in violent crime in 2023, consistent with trends in many urban centers, that trend had sharply reversed. Violent crime in Washington had dropped 35% in 2024, hitting its lowest level in over 30 years.
35% drop. So it wasn't surging.
Quite the opposite. And it continued its decline, falling an additional 26% in the first half of 2025. So the data clearly indicated a significant decrease in violent crime rather than the wave of lawlessness the president described, prompting many to question the factual basis of the justification.
So Mayor Muriel Bowser must have challenged those claims, given the clear statistical evidence that contradicted the president's narrative.
She did. D.C.'s Mayor Muriel Bowser openly challenged Trump's claims, accurately pointing out that the capital's violence was at a 3-decade low. This put her directly at odds with the president's narrative, illustrating a clear discrepancy between the stated justification and the objective reality on the ground.
What was the legal basis for such a significant intervention in D.C., and how is it perceived from a legal standpoint? I know D.C.'s status is complex.
Trump's D.C. intervention relied on a seldom-used provision of the city's Home Rule Act of 1973.
The Home Rule Act, okay.
This act allows a president to assume control of local police for a temporary period, specifically 30 days, if they declare an emergency. Trump declared a public safety emergency to trigger this provision.
And the Guard deployment was more straightforward legally.
Correct. From a legal standpoint, the president already directly commands the D.C. National Guard, as D.C. is not a state, which made their deployment significantly easier than federalizing a state guard, as in California.
So while the Guard deployment was more straightforward, the police takeover still generated considerable legal and political contention, correct?
Exactly. While the D.C. National Guard is always under presidential command, the unilateral takeover of the city's police department was notably controversial. Mayor Bowser and other local officials described Trump's actions as unwarranted and potentially exceeding legal authority.
Did they threaten legal action?
Yes. D.C.'s Attorney General Brian Schwab went further, deeming the takeover unlawful, and stating he was considering all of our options to challenge it legally. Furthermore, hundreds of federal agents from agencies like the FBI and Department of Homeland Security had already been deployed to D.C. in the days leading up to the announcement, creating a multi-agency security presence in the city.
A federal presence even before the takeover.
Yes. And as part of the takeover, Attorney General Pam Bondi, a staunch Trump ally, was named to oversee D.C.'s police during the takeover, which was widely seen as a further solidification of direct executive control.
And it wasn't just D.C. that was potentially subject to these types of interventions, was it? There were broader implications suggested.
This is where the implications broaden significantly. President Trump publicly discussed extending similar measures to other Democrat-led cities.
Like Chicago.
He specifically named Chicago, which, much like D.C., was also experiencing declining crime rates in 2025. He was quoted saying, "If we need to, we're going to do the same thing in Chicago. Hopefully L.A. is watching."
Wow. So explicitly linking it to other Democratic cities.
This statement, in the view of many analysts, appeared to connect crime fighting with a clear show of political force against cities led by political opponents. It suggested a pattern where federal intervention might be less about objective public safety needs and more about asserting federal control and sending a political message to perceived opposition.
So we've examined these two distinct but related situations. What's the common thread that connects the events in Los Angeles and Washington, D.C.? What insight emerges when we look at them together?
The common thread in these two distinct situations is critical for understanding patterns that may contribute to democratic backsliding. In both instances, rhetoric about public order appeared to be used in conjunction with moves that concentrated power in federal executive hands.
Concentrated power.
Yes, and this simultaneously bypassed local authorities, who are typically responsible for domestic law enforcement, and potentially conveyed a message to opposition voices or politically unfavorable groups.
And the justifications didn't quite hold up to scrutiny.
The justifications offered, when examined against available data and intelligence, revealed discrepancies, suggesting that the primary objective might have been the centralization of executive power and the assertion of federal control, rather than a direct response to an immediate, objectively measured emergency.
Okay, let's consolidate what we've just discussed and highlight the key points. This is our end-of-chapter mega recap for this first section.
Recap. We've observed a distinct pattern emerging where federal forces took action that, critics argued, overrode local governance in two major U.S. cities. These actions were justified by claims of widespread disorder and dire threats, yet these claims were consistently met with contradictory objective data and internal intelligence assessments.
Right. The data often didn't match the claims.
Despite the official justifications, these maneuvers appeared to centralize power within the executive branch, bypassing established democratic norms and local autonomy. This deliberate bypassing of traditional structures represents a significant analytical point.
And for some key terms to remember from this section, let's quickly run through those flashcards conversationally. First, the Los Angeles raids.
Those were the ICE operations in June 2025, leading to at least 44 arrests at places like day labor sites, sparking those big local protests.
Then, the CA federalization.
That's when Trump federalized California's National Guard 4,000 troops, plus 700 Marines against Governor Newsom's will, a real assertion of federal power over the state.
Next, the D.C. takeover.
August 2025, deployment of 800 Guard troops, but more importantly, the unilateral takeover of the D.C. Metropolitan Police, bypassing the mayor and council.
And the crime stats in D.C.
Crucial context. The administration claimed a wave of lawlessness, but violent crime was actually down 35% in 2024, reaching a 30-year low, and fell another 26% in early 2025.
The Home Rule Act.
That's the D.C. law Trump used for the first time ever by a president, allowing temporary federal control of local police under a declared emergency.
And finally, political spectacle.
Governor Newsom's term for the federal deployments in California, suggesting the goal was more about display and intimidation than actual need.
Okay. Moving on from these immediate events, let's turn our attention to the significant legal challenges that promptly followed these deployments. These actions prompted considerable legal scrutiny, raising fundamental questions about their constitutional basis and the limits of executive power.
Yes, the courts got involved very quickly.
Can you walk us through the California lawsuit and the core statutes that were central to it?
The legal challenges were indeed swift. Governor Newsom and California's Attorney General Rob Bonta immediately filed a lawsuit against the Trump administration. Their central argument rested on alleged violations of both state sovereignty, the inherent authority of California as a state and existing federal law.
And the key law was?
Central to their legal argument was the Posse Comitatus Act of 1878. This 19th century law, along with related statutes, is a cornerstone of American civil-military relations, explicitly prohibiting the use of the U.S. military in civilian law enforcement except under very strict specific conditions.
So this act is fundamentally designed to prevent the military from operating as a domestic police force in civilian affairs. Correct. Keep the military out of policing.
That's precisely its core purpose. It embodies America's long-standing norm against military involvement in domestic policing, a principle that traces its origins to historical concerns about a standing army being used to suppress its own citizens.
And California argued the LA deployment crossed that line.
California's lawsuit contended that by utilizing National Guard soldiers, and even more significantly, active-duty U.S. Marines, to assist ICE in arresting civilians on U.S. soil, President Trump had, in their view, directly crossed this clearly defined legal line.
What did the Attorney General say specifically?
Attorney General Bonta was quite explicit in his legal filings, stating, and I quote, "The federal government deployed military troops to the streets of Los Angeles for the purposes of political theater and public intimidation," further emphasizing what he described as the unprecedented nature of this move in U.S. history.
Political theater and public intimidation. Strong words in a legal filing.
Indeed. This legal challenge was therefore not merely about a technical violation, but about a perceived fundamental breach of democratic principles.
And Title 32 of the U.S. Code, which governs the federalization of the National Guard, also played a crucial role, didn't it? That sets the conditions for federalizing the Guard.
Title 32 is indeed crucial in this context. It outlines the specific conditions under which a president can federalize a state's National Guard, placing them under federal command. These conditions are typically tightly constrained and include situations like suppressing an insurrection or a rebellion against federal authority, or when local forces are demonstrably unable or unwilling to enforce federal law.
Which links back to the administration not invoking the Insurrection Act.
Exactly. The lawsuit hinged on whether the situation in Los Angeles met these stringent criteria as defined by federal law under Title 32.
So how did the initial court ruling from Judge Breyer respond to California's arguments? Was it a clear legal victory for the state in the initial stages?
Initially, yes. It was considered a significant legal victory for California. On June 12th, U.S. District Judge Charles Breyer, presiding in San Francisco, sided with California on a key point.
What was his ruling?
He ruled that Trump had violated a law governing when a president can take control of a state's National Guard. Judge Breyer's reasoning was methodical and clear. He found that the required conditions for federalization under Title 32 did not exist in Los Angeles.
No insurrection, no rebellion.
Right. He determined there was no actual rebellion or a collapse of order on the ground that would legitimately warrant the removal of the Guard's control from the governor. Furthermore, the judge noted that the Trump administration had failed to properly consult or coordinate with Governor Newsom before taking the step of federalizing the Guard.
So he ordered them back under state control.
His order was explicit. He directed the California Guard return to state control and essentially instructed the White House to stand down in L.A., at least concerning the Guard's federalized status.
So a strong initial ruling. But that victory for California was temporary, wasn't it? The Ninth Circuit Court of Appeals subsequently intervened. Things often get more complex on appeal.
It was indeed temporary, as is often the case. Trump's lawyers immediately appealed to the Ninth Circuit, and on June 19th, the appellate court stayed, or paused, Judge Breyer's order. A three-judge appellate panel then extended this pause, indicating an initial inclination toward the administration's position.
On what grounds?
The court's reasoning was nuanced. They suggested that Trump probably acted within his authority in activating and federalizing the Guard, implying that a governor, while typically controlling their Guard, cannot unilaterally veto a president's order on calling up the Guard for federal purposes.
That sounds like a partial legal affirmation for the administration. But there was a crucial caveat, wasn't there? Something about how the forces could be used, rather than just their activation. This seems key.
You've identified the critical distinction. While the Ninth Circuit indicated the activation might be lawful, they introduced a significant caveat. Nothing in our decision addresses the nature of the activities in which the federalized National Guard may engage.
Ah, so the use of the troops was still up for debate.
Exactly. This was a crucial point. It left the door open for California to continue arguing that even if Trump could deploy the Guard, using them as direct law enforcement agents on the streets to arrest civilians would violate other laws, specifically the Posse Comitatus Act.
So Posse Comitatus remained the central issue.
Yes. The appellate judges explicitly noted that Governor Newsom could continue to challenge the use of both the Guard and the Marines under those laws that specifically prohibit military involvement in civilian policing. This set the stage for a deeper legal confrontation focused on the role and actions of these deployed forces.
Okay, another micro recap point, around the 10-minute mark. We've just navigated the immediate legal challenges to the federal deployments. What's the takeaway here?
We've seen an intricate legal process surrounding these federal deployments, with courts grappling with historic statutes like Posse Comitatus and the delicate balance between executive power, state sovereignty, and democratic norms.
A real tug-of-war.
The administration's broad interpretation of its authority faced significant legal challenges rooted in safeguarding what critics describe as the fundamental guardrails of democracy. While an initial court ruling favored California by questioning the basis for federalizing the Guard, a higher court paused that, but crucially left open the critical question of how those forces could be used, particularly in relation to the Posse Comitatus Act.
Right.
This highlights the ongoing tension between executive power and established legal guardrails.
So this specific legal challenge was so significant that it progressed to a landmark trial concerning the Guard and Marine deployment commencing in August 2025 in Judge Breyer's court. This trial became a key forum for presenting evidence and arguments under judicial scrutiny.
That's right. It moved beyond initial injunctions to a full trial on the merits.
And what evidence emerged during this landmark trial that either supported or perhaps challenged the administration's claims regarding the necessity of these deployments?
During the trial, compelling evidence emerged that provided further support for California's claims. Major General Scott Sherman, who was the Army officer leading the Los Angeles military operation, provided critical testimony.
The commander on the ground.
Yes.
Yeah.
He stated under oath that military intelligence had foreseen little risk to federal facilities during the planned immigration raids. This directly contrasted with the administration's public portrayal of Los Angeles as a city under siege and at risk of widespread violence.
So the military's own assessment didn't support the immediate need for such a massive deployment again.
Correct. And even more notably, General Sherman admitted that he had initially denied a request for military assistance due to this low threat assessment.
He denied it initially. Then why were they deployed?
This decision was later overruled due to what he described as political pressure, including a direct intervention by then Defense Secretary Pete Hegseth.
Political pressure overriding military assessment. Did Judge Breyer further question General Sherman on this point?
He did. Judge Breyer directly pressed General Sherman, asking, in essence, if there is no clear, imminent threat, can the military still be deployed just in case? General Sherman's response was yes.
Just in case.
This stance, while perhaps reflecting certain military planning principles, solidified California's argument that the deployment was disproportionate and, critically, potentially outside the legal bounds for civilian law enforcement assistance.
And were troops still active during the trial?
By mid-August, most troops had finally been withdrawn from Los Angeles, but a contingent remained. About 300 National Guard members were still accompanying ICE agents on raids and were reported by Attorney General Bonta to be restricting civilian movements in certain areas, continuing to raise questions about their role.
So the core of the legal argument then consistently revolved around the Posse Comitatus Act, didn't it? Even if the forces could be activated, how they were utilized was the key issue.
Precisely. The Posse Comitatus Act, which explicitly prohibits the Army, Air Force, Marines, and Federalized Guard from direct civilian law enforcement activities, was central to the trial. California argued that President Trump's deployment represented a direct violation of this fundamental American law.
What was their evidence for that?
They presented evidence suggesting that troops were actively making arrests and engaging in activities typically associated with civilian law enforcement, such as assisting IC in raids, which are actions largely without precedent in modern U.S. domestic operations.
And the Justice Department's counterargument.
In response, the Justice Department contended that the troops were only there to protect federal property and personnel, such as ICE officers, and not to engage in policing civilians. A fine line, perhaps.
Protect personnel versus enforce the law. It's a subtle but crucial distinction legally.
It is. The outcome of this trial remained pending, but it powerfully underscored the judiciary's essential role in defining the boundary between legitimate security measures and actions that critics argued pushed the limits of constitutional authority.
Now, the legal situation in Washington, D.C. was somewhat different due to its status as a federal district. How did that particular dynamic play out in terms of legal challenge?
D.C.'s unique status as a federal district grants the president greater inherent authority regarding local control. Mayor Bowser herself acknowledged this, noting that the relevant law appeared to give the president broad power for a temporary police takeover.
That was the Home Rule Act again.
Yes, the Home Rule Act of 1973 indeed allows for temporary federal control of D.C.'s police under emergency conditions. President Trump's August 11th order was, in fact, the first time any president had ever invoked this specific provision.
The first time ever. So were there challenges?
While D.C.'s Attorney General indicated that Trump's actions were not above scrutiny and that the city would explore court challenges, the legal avenues were more constrained. Unlike California, there is no governor in D.C. to directly sue the president, and ultimately, Congress holds significant authority over the district.
Making it more political than legal, perhaps.
Exactly. This meant the D.C. intervention became as much a political confrontation as it was a purely legal one.
And beyond the specific legalities, there was a deeper concern about the precedent this action set, wasn't there? The idea of the president taking over a city's police force.
Indeed. The scenario of a president temporarily assuming control over a major U.S. city's local law enforcement structure was perceived by many observers as a significant step, one more commonly associated with systems undergoing democratic decline than with established democracies like the United States.
And he hinted at more.
What's more, President Trump publicly discussed the possibility of a broader takeover of D.C.'s governance. In the days leading up to the police takeover, he discussed stripping the city of its local autonomy entirely if crime was not addressed to his satisfaction.
Stripping local autonomy. That's a very strong statement.
Such discussions prompted concern among many analysts, recalling historical instances where central authorities place cities or states under direct rule. While technically within a president's arsenal under certain interpretations, these actions are almost never used in a healthy democracy due to strong democratic norms that prioritize local autonomy and separation of powers. Their very consideration signaled a willingness to challenge those established norms.
So what does this summary of these legal battles ultimately tell us about the core principles at stake here? What's the biggest analytical takeaway?
These court battles fundamentally revolve around a critical question for any functioning democracy. Who possesses the authority to wield the tools of force domestically, and under what specific legal and constitutional constraints?
Who gets to use force and when?
Exactly. The Trump administration's stance in these legal challenges was interpreted by many as maximalist. It argued that once the president declares an emergency or a threat, his decisions should not be subject to judicial or state-level review.
The executive power shouldn't be second-guessed.
That was the implication. Publicly, President Trump framed his actions as simply necessary to protect citizens when, in his view, local leaders were unwilling or unable to do so. However, the strong pushback from judges and state officials highlighted a deep, pervasive concern that these executive actions were potentially breaching established guardrails that define the separation of military and police roles, and the crucial guardrails between federal and local authority. These guardrails, importantly, exist to mitigate the risks of unchecked executive power.
Fascinating. Okay, let's do our end-of-chapter mega recap for the legal section now. So, summarize the key legal dynamics.
Recap. We've seen an intricate legal dance surrounding federal deployments, with courts grappling with historic statutes like Posse Comitatus and the delicate balance between executive power, state sovereignty, and democratic norms. The administration's maximalist view faced strong opposition rooted in safeguarding the very guardrails of democracy.
And the key flashcard terms for this legal section, let's run through them. Posse Comitatus Act, 1878.
That's the core law barring federal military from civilian law enforcement, the central point of contention in the California case.
Title 32, U.S. Code.
Governs when a president can federalize a state's National Guard. The conditions Judge Breyer initially found were not met in L.A.
Judge Charles Breyer.
The district judge who issued that initial ruling against Trump's CA Guard federalization.
Ninth Circuit.
The appeals court that paused Breyer's order, but, crucially, kept the door open for the Posse Comitatus challenge based on how the troops were used.
Darrell Scott Sherman.
His testimony about low-threat intelligence undermined the administration's justification for the LA deployment. A key piece of evidence.
D.C. federal district status.
Gives the president more leeway over local police via the Home Rule Act, making the D.C. situation legally distinct.
And finally, guardrails.
The legal and constitutional limits separating military police roles and federal local authority, the principles at the heart of these legal battles.
Okay. Beyond these dramatic headline-grabbing deployments, the administration has also been pursuing a broader expansion of its domestic enforcement capabilities through legislative action and shifts in policy, particularly in the realm of immigration enforcement. Let's talk about the July 4, 2025 spending bill, which allocated significant resources for domestic security.
This is a crucial component for understanding the overall pattern, as it provides the financial and structural foundation for this expanded capability. President Trump signed a sweeping tax cut and spending bill championed by congressional Republicans.
A spending bill, not just an immigration bill.
Correct. What's significant is that, embedded within its hundreds of pages, was substantial funding specifically earmarked for domestic security and immigration control. This wasn't a standalone immigration bill, but a comprehensive financial package that notably bolstered the domestic enforcement apparatus.
How significant was this financial allocation, according to independent analysis? What kind of numbers are we talking about?
A Reuters analysis of the bill's provisions revealed substantial figures. A total of $170 billion was allocated specifically for immigration enforcement programs.
$170 billion. That's a huge number.
It is. To provide context, this represents a considerable sum dedicated to internal control mechanisms. A large portion of this, $45 billion, was directed towards significantly expanding detention capacity for immigrants.
Expanding detention, how much?
This funding raised the officially funded daily detention population from the previous 41,500 beds to an astonishing at least 100,000.
100,000 beds. That represents a very substantial increase, roughly double the detainee count at the peak of the 2018-2019 border influx. What are the practical implications of such a significant expansion in detention capacity?
The practical implications are profound. The U.S. government now possesses the financial means and infrastructure to detain 100,000 people at a time in ICE facilities. As of mid-June 2025, ICE was already detaining approximately 56,000 migrants, which was already above its older capacity. This clearly indicated that the administration anticipated filling these new beds very quickly. This expansion directly supports President Trump's publicly stated vow of mass deportations, providing the necessary physical infrastructure for such an ambitious and large-scale operation.
And it wasn't just detention capacity, was it? There was also a notable increase in funding for ICE's enforcement operations. More boots on the ground, so to speak.
Precisely. The July 4th law allocated an additional $30 billion into ICE's enforcement and removal operations. This effectively tripled that budget from around $10 billion the year before.
Tripled the budget for enforcement.
Yes. This funding is explicitly earmarked to hire and train thousands of new ICE officers and agents, with the potential to double ICE's ranks. Earlier drafts of the bill even contemplated hiring 10,000 new ICE officers over 5 years.
Doubling ICE.
Potentially. This significant increase in personnel enables far more widespread operations, including raids and arrests deep within the U.S. interior, extending ICE's reach significantly beyond traditional border regions.
And other agencies too, CBP. The wall.
Yes. The law also boosts funding for Customs and Border Protection, or CBP, hiring, with another $4.1 billion for more Border Patrol agents, and critically, $46 billion for border wall construction at the southern border.
What's particularly striking here is the juxtaposition of this massive spending. All this funding for border security and immigration enforcement is being deployed at a time when, if I understand correctly, unauthorized border crossings have actually experienced a significant decline. Is that right?
That's one of the most notable discrepancies. This considerable expenditure on border and internal enforcement comes at a time when unauthorized crossings have plummeted. The number of migrants caught crossing illegally dropped to record lows after President Trump took office in January 2025.
Record lows, yet record spending on enforcement.
Exactly. This suggests that the border emergency frequently cited by the administration might be characterized by some observers as exaggerated, given that illegal entries were at modern lows. Nonetheless, the administration is building up extensive capacity for detention and removal, indicating a strategic long-term vision for internal control independent of current border realities.
It's not just about the money and the personnel, but also about significant shifts in policy that impact due process protections. Can you elaborate on the ICE bond memo and its implications? This sounds important.
This is where the legal and humanitarian implications become particularly important. In mid-July, an internal ICE memo revealed a significant new policy aimed at denying bond hearings to many immigrants in custody.
Denying bond hearings. Explain that.
Traditionally, under U.S. law, many detained immigrants, especially those without serious criminal records, asylum seekers, or those awaiting deportation proceedings, have been eligible for a bond hearing in immigration court. During such a hearing, an immigration judge determines if they can be released on bond while their case proceeds through the system.
And this new guidance appears to remove that possibility for many categories of individuals. Just no chance of release.
Exactly. The new guidance directs ICE to interpret several immigration statutes as prohibitions on release. This effectively mandates no bail for vast categories of detainees. The memo indicates this policy could apply to millions of people who cross the border illegally and are contesting their deportation.
Millions.
That's the potential scope cited. The practical consequence of this is to detain them indefinitely without an opportunity for release on bond. This not only swells the numbers of those held in detention facilities, directly supporting the infrastructure expansion we just discussed, but it also exerts considerable pressure on migrants to abandon their legal claims, as fighting a case from inside a detention center without the ability to freely access legal counsel or gather evidence is significantly more challenging.
That sounds like a notable departure from established legal norms. How did legal experts react to this policy shift?
Legal experts expressed considerable concern. A former Homeland Security official stated that the shift appeared to reverse legal standards governing detention for decades, describing it as a radical departure that could explode the detention population.
Did the administration expect challenges?
The administration was aware of the legal challenges this would likely generate. The memo itself acknowledged that the new policy was likely to be litigated. Indeed, at least one lawsuit was promptly filed, arguing that denying case-by-case bond hearings violates statutory and constitutional rights to due process, specifically referencing the Supreme Court case Zadvitas v. Davis from 2001, which established limits on indefinite detention without a bond hearing. This new policy represents a clear effort to push the boundaries of executive power by curtailing a fundamental due process right.
Okay, around the 15-minute mark now. Let's do our micro recap to crystallize what we've just discussed about the legislative and policy shifts that are significantly expanding the state's enforcement capabilities. What's the main insight here?
We've explored how legislation and policy changes are dramatically increasing the U.S.'s capacity for internal enforcement. The enormous funding allocated for detention and enforcement, coupled with new policies that curtail due process rights like bond hearings, points to a clear, large-scale effort to control and process specific populations.
Even when the justification seems questionable.
Yes, this is occurring even as the stated justifications, such as a border emergency, are met with contradictory objective data. This systematic buildup of power for domestic enforcement raises significant analytical questions.
And for some key terms to remember from this section, first, $170 billion.
That's the huge total allocation for immigration enforcement programs in that July 4, 2025 spending bill.
100,000 beds.
The new expanded funded daily detention capacity for immigrants, a massive jump.
$30 billion.
The tripled budget specifically for ICE's enforcement and removal operations, funding more agents and raids.
No bond hearings.
The controversial new ICE policy denying release options for many detainees, leading to prolonged detention.
3,000.
The reported White House quota for ICE migrant arrests, pushing for high-volume apprehensions.
And Alligator Alcatraz.
The memorable nickname for that large temporary detention camp in Florida, symbolizing the push for mass, potentially ad hoc detention facilities. These policy shifts, the dramatic expansion of detention capacity, and the deliberate removal of avenues for release, fundamentally redefine ICE's role. The agency is being significantly retooled, shifting from a law enforcement body that manages immigration violations with some measure of judicial oversight into something more akin to an instrument of mass detention and removal, largely at the executive's discretion.
A real transformation.
This represents a significant shift in its operational mandate and its very identity.
And the administration is justifying this transformation with some notably ambitious goals, correct? Like that arrest quota.
Absolutely. President Trump and his aides openly justify this as necessary to apprehend and remove illegal aliens in unprecedented numbers. The White House has reportedly set a challenging goal: a quota for ICE to arrest at least 3,000 migrants per day. This far exceeds any past operations in scale and ambition.
3,000 a day. How do they achieve that?
To achieve such an aggressive target, ICE would likely need to expand its operational scope significantly, and that's precisely what appears to be happening. They have to cast a very wide net.
So a sweeping crackdown implies they're apprehending more than just those with serious criminal records. It sounds like it could catch others too.
Indeed. The sweeping immigration crackdown observed in Los Angeles, for example, reportedly caught up people legally residing in the country, including some with permanent residence, and this subsequently led to legal challenges for alleged wrongful detention.
Legal residents caught up in raids.
That's what was reported. This indicates a potential broadening of enforcement. Under pressure to boost arrest numbers, ICE agents may detain not only undocumented immigrants, but also individuals who, by law, might not be deportable. Such a broad approach raises questions among critics about the apparatus being used in a less targeted manner than officially stated, or even, as some argue, against groups perceived as undesirable.
And then there's the concept of these large-scale detention camps. I recall hearing about something called Alligator Alcatraz. Tell us more about that model.
Yes, that's a particularly vivid and illustrative example. In early July, President Trump visited a temporary detention center located in the Florida Everglades. This was a sprawling camp of tents in the swamp, which was quickly dubbed Alligator Alcatraz.
Catchy name.
It had been established by Florida's Republican government specifically to hold overflow detainees from immigration operations. President Trump publicly praised Florida's model of erecting these large temporary facilities to hold migrants and noted that other states could follow the same model.
So replicated elsewhere.
He even indicated that Florida would be reimbursed with federal emergency funds for these efforts. This suggests a potential strategy to create a network of ad hoc camps that could emerge across the country, financed by federal dollars, to accommodate large-scale raids or mass arrests.
And the spending bill supported this.
Yes, the July spending law even formalized some of this, creating a $10 billion fund to reimburse states for assisting in securing the border, which is a clear acknowledgement of states like Texas and Florida that are dedicating resources to immigration enforcement.
So if I'm understanding this correctly, all these measures, the substantial funding, the expanded personnel, the new policies, the development of detention facilities, they all appear to contribute to what one might describe as a coercive feedback loop. Can you explain that?
That's an insightful way to conceptualize it. All these measures do indeed appear to feed a self-reinforcing feedback loop. More financial resources for enforcement, more officers on the ground, more beds for detention, and fewer legal constraints on executive action tend to result in an increase in arrests and detentions.
Which then justifies more enforcement.
Exactly. This increased activity then, in turn, can be used to justify further rounds of enforcement, creating a continuous cycle. It represents a systematic and deliberate buildup of a domestic security apparatus on a scale not seen in recent American history, a framework that observers argue prioritizes control and enforcement, sometimes at the expense of typical due process and individual liberties.
Okay, let's consolidate our understanding and capture the key terms from this section on escalation. What's the core takeaway here?
Recap. We've seen how legislation and policy shifts are significantly expanding the U.S.'s capacity for internal enforcement. Through substantial funding for detention and personnel, coupled with policies that curtail due process and aim to increase arrest quotas, the administration is building a broad domestic enforcement apparatus.
An apparatus running on its own momentum almost.
It appears to operate on a logic of increasing scale, even when objective emergencies are not fully supported by data. This systematic buildup of power for domestic enforcement presents a significant area for analysis.
And for some key terms to remember from this section on escalation. $170 billion.
The total funding for immigration enforcement in the big July 4th bill.
100,000 beds.
The vastly increased daily detention capacity.
$30 billion.
The tripled budget for ICE enforcement and removal.
No bond hearing.
The policy shift limiting release options for detainees.
3,000, yeah.
The reported White House arrest quota for ICE.
And alligator Alcatraz.
The Florida camp model for mass temporary detention.
This pattern of utilizing security forces and emergency powers domestically, as we've discussed, is not unique to the United States. It has historical parallels abroad and echoes in American history. Let's begin with contemporary example. El Salvador's state of exception. What does this case study offer in terms of comparative lessons?
El Salvador offers a relevant and, for many, concerning contemporary example. Starting in March 2022, Salvadoran President Nayib Bukele declared a state of emergency or state of exception to combat pervasive gang violence, which was indeed a serious and disruptive problem in the country.
A real crisis they faced.
Yes, but in doing so, he unilaterally suspended various constitutional rights.
And what was the scale of arrests and the impact on due process in El Salvador under this state of exception? How did it play out?
The scale of enforcement was immense. Over a period of 3 years, from 2022 to 2025, Bukele's security forces arrested nearly 75,000 people for alleged gang connections.
75,000. That's a huge number for a small country.
It is. And crucially, this was often done with minimal due process. What's particularly notable here is that the judiciary largely ceased to function as a significant check on executive power. Detainees lost their right to legal defense, and as critics observed, they could be held for extended periods without formal charges, as these emergency decrees were renewed month after month, effectively becoming a continuous feature of governance.
So what were the reported results of this crackdown, and how was it generally received by the public in El Salvador? Did people support it?
The government reported a significant drop in homicides, claiming a 70% fall in murders in 2023, which they directly attributed to the crackdown.
So crime went down.
Yes, and this led to widespread public support for Bukele's approach within El Salvador itself. Many citizens, having endured years of pervasive gang violence, welcomed the perceived increase in security, even if it came with a cost to civil liberties.
Which illustrates a critical dynamic, right? People might accept harsher measures if they feel safer.
Exactly. Actions aimed at restoring order, even if controversial in their methods, can gain significant public support if they appear to effectively address genuine social problems like crime.
But what were the human rights implications of this approach? What was the cost? It sounds like there must have been one.
The human rights cost was described as significant. International monitors, including Amnesty International and the Inter-American Commission on Human Rights, documented systematic and widespread arbitrary arrests, illegal raids, and excessive use of force by Salvadoran authorities.
Systematic and widespread abuse.
That's what they reported. They reported thousands of alleged abuse cases, including torture of prisoners, the detention of over 60 children alongside adults, and at least 190 in-custody deaths linked to harsh and, critics argued, inhumane conditions.
190 deaths in custody.
Many observers concluded that El Salvador had, in practice, traded aspects of the rule of law for mass incarceration in the name of public security, prompting warnings of an alarming regression in human rights and a rapid shift toward what some described as authoritarian practices.
And what's particularly notable about the El Salvador example is that a state of exception, which is inherently meant to be temporary, has effectively become a permanent feature. Is that correct?
This is a crucial analytical takeaway. Bukele's state of exception, initially intended as a temporary measure to address an acute crisis, has been renewed continuously for over 3 years, to the point that observers now note it has become a de facto permanent fixture of the country's security policy.
Permanent emergency rule.
Essentially. The suspension of certain rights, such as typical fair trial guarantees or the presumption of innocence, is justified by the government as a necessary price for peace and security. The lesson for the U.S. context, as a comparative lens, is cautionary. It demonstrates how a narrative emphasizing an extraordinary crime threat requiring extraordinary measures can potentially lead to sustained emergency rule and the normalization of policies that limit individual liberties.
And you see parallels in the language used.
The U.S. administration's own use of language, such as declaring a war on gangs, on chaos, to rally support for troop deployments or expedited deportations, reflects a similar rhetorical dynamic. It frames the situation as existential, requiring exceptional responses.
Okay, let's do our micro recap here on the 20-minute mark. We've just analyzed how public order rhetoric can morph into entrenched authoritarianism by looking at El Salvador's state of exception. What's the main insight?
We've analyzed how rhetoric concerning public order can, in some contexts, lead to entrenched shifts in governance, as seen in El Salvador's state of exception. Addressing gang violence in that case reportedly led to widespread human rights concerns and a de facto continuous suspension of some rights.
Trading rights for security.
Essentially. This highlights a recurring challenge for democracies, maintaining a balance between security and fundamental freedoms, and understanding how that balance can be significantly altered, sometimes permanently.
Now, let's look back at U.S. history, because there are precedents where domestic security forces were utilized in ways that later became subjects of public and legal scrutiny. One significant example is the FBI's COINTELPRO, the counterintelligence program, which operated from the 1950s through the 1970s. What was that about?
COINTELPRO was a series of covert and, in some cases, illegal projects orchestrated by J. Edgar Hoover's FBI. Its stated aim was to surveil, infiltrate, and disrupt domestic political movements deemed subversive by the government.
Subversive movements? Like who?
The list of targets was extensive, encompassing a wide array of activists and dissenters. This included prominent civil rights groups and leaders, such as Dr. Martin Luther King Jr. and the Black Panthers, anti-Vietnam War organizations, and various feminist and minority rights movements. Interestingly, some far-right groups, like the Ku Klux Klan, were also subjects of investigation, indicating a broad scope of internal surveillance.
And the tactics they employed were described as quite extreme, weren't they? Not just surveillance.
They were. Under COINTELPRO, the FBI employed a range of tactics designed to surveil, harass, discredit, and at times entrap or weaken the leaders and movements they targeted. These tactics included spreading false media stories to damage reputations, forging documents to sow distrust and discord within organizations, and even cases of wrongful imprisonment on charges that were later disputed.
And sometimes violence.
In some particularly scrutinized cases, the program was linked to facilitating violent outcomes. The killing of Black Panther leader Fred Hampton in 1969 is often cited as a stark example. He was under FBI surveillance, and a police raid, reportedly coordinated with an FBI informant, resulted in his death.
Coordinated by the FBI.
That was the finding. A U.S. Senate investigation later concluded that COINTELPRO's ultimate goal was protecting national security and maintaining the existing social and political order, which in practice meant addressing challenges to the government's policies or authority.
This presents a powerful illustration of a democratic government directing its security apparatus toward its own citizens, specifically those perceived as domestic opponents, using the FBI against Americans.
Precisely. It's a significant illustration of a democratic government utilizing its security apparatus domestically against perceived opponents, who were largely peaceful civil rights and anti-war protesters, often under the broad justification of preserving order.
And it was secret.
What's particularly notable is that much of this was conducted secretly at the time. When it was exposed in 1971, it was widely condemned as a profound breach of fundamental American principles regarding civil liberties. The COINTELPRO era serves as a crucial historical reminder that even within a democracy, agencies can, critics argue, be influenced to prioritize the preservation of existing order, especially if strong oversight is lacking and a narrative of fear of internal enemies is cultivated.
Another historical parallel brings us to the tumultuous year of 1968, specifically the Democratic National Convention in Chicago. A very different context, but relevant.
Yes, 1968 was a year marked by profound social unrest, with widespread protests against the Vietnam War and the political establishment. During the Democratic National Convention in Chicago in August of that year, thousands of anti-war demonstrators gathered to voice their dissent.
And the police response?
The response from Chicago authorities, under then-Mayor Richard Daley, was characterized by many as heavy-handed. Police and National Guard units took forceful action against the protesters, employing methods that included physical force and the use of tear gas against crowds in the streets.
The images from Chicago were famously televised and sparked national debate, didn't they? Chance of the whole world is watching come to mind.
Indeed. The events and their visual documentation were televised nationally, generating significant public discussion and concern. The chants of "the whole world is watching" were heard as individuals were reportedly subjected to force by officers, creating a visual record that prompted scrutiny.
And what did the official investigation conclude?
Subsequent investigations, notably the Walker Report commissioned by the U.S. National Commission on the Causes and Prevention of Violence, concluded that what occurred was, in fact, a police riot. a term used to describe unprovoked excessive force by authorities against citizens, which the report suggested was prompted by governmental intolerance of dissent. Over 500 protesters were reported injured and many dozens hospitalized.
A police riot.
This event drew attention to the potential dangers of deploying state force in the name of law and order when, in critics' view, the underlying aim might be to suppress anti-war voices and political opposition.
While not a direct one-to-one comparison to the events of 2025, it still offers a relevant historical warning, doesn't it? Particularly the justification aspect.
It does. While the 1968 protesters were not accused of being criminals or illegal immigrants, they were openly political demonstrators, the event serves as a crucial historical point for discussion. At that time, leaders sometimes justified the actions by labeling protesters as disloyal or disruptive.
Which sounds familiar.
This bears a resemblance to how some officials today have characterized immigrant rights protesters as insurrectionists. The pattern of characterizing a specific group in negative terms to justify assertive measures by the state is a recurrent theme throughout history, regardless of the specific context. Demonization as a tool.
So, what's the overarching analytical takeaway from this comparative analysis? Looking at both international and U.S. historical examples, what connects El Salvador, COINTELPRO, and Chicago 68?
Both the international and U.S. historical examples underscore a critical point. Campaigns framed around public order can, in some circumstances, contribute to trends that observers describe as government preservation and political control.
The language is seductive, though. Order. Safety.
Exactly. The language used to justify such actions, addressing perceived threats, stopping disruption, restoring stability, can be compelling and may reflect genuine concerns, as crime and disorder are real issues that require governmental response. However, the crucial differentiator, many analysts argue, is when the response involves the suspension of typical legal protections and a notable concentration of power in the executive or within security forces. When we observe these specific conditions, they often align with historical patterns that raise questions about democratic integrity.
Okay, let's consolidate our understanding and capture the key terms from this comparative section. Time for another end-of-chapter mega recap.
Recap. Examining El Salvador and U.S. history, we find recurring patterns where the pursuit of public order can lead to significant shifts in democratic norms. The normalization of emergency rule, the use of state agencies in contexts perceived as targeting political dissent, and the characterization of specific groups are all historical dynamics that prompt critical examination of current events. The underlying mechanisms appear consistent across different contexts.
And the key flashcard terms for this comparative section. El Salvador State of Exception, 2022-2025.
The contemporary example of suspended rights, mass arrests, and permanent emergency rule justified by fighting gang violence.
COINTELPRO, 1950s-70s.
The FBI program using covert tactics to disrupt domestic political movements aimed at maintaining the existing order.
Fred Hampton, 1969.
The Black Panther leader killed in a raid linked to COINTELPRO, illustrating the potential for violence.
1968 Chicago DNC.
Where excessive force against protesters was labeled a police riot, showing official response to dissent.
And characterization demonization.
The common tactic of framing groups negatively to justify harsh state actions against them.
This brings us to the core, most critical question for our analysis. When does rhetoric about law and order and public safety evolve from being about genuine public protection into what critics describe as a framework primarily supporting government preservation? A government's fundamental duty is often cited as protecting its citizens' safety, but how do we discern this distinction? It feels like a crucial line to identify.
This question goes to the very essence of the issue, and it's a distinction that requires careful analytical scrutiny. A key indicator that observers point to when discussing a potential shift is when measures ostensibly taken to protect the public appear to significantly exceed the actual threat, or when those measures are selectively applied in ways that suggest a broader motivation, such as targeting political opposition or marginalized groups.
Exceeding the threat, or being applied selectively.
Yes. It's about examining the practical application of policy versus its stated intent.
So let's break down these potential indicators, starting with what might be termed a disproportionate response. How did we see that play out in D.C. and L.A.?
In the case of Washington, D.C., the proportionality of the response drew considerable analytical attention. President Trump declared a significant emergency and sent troops into the Capitol after violent crime had already reportedly dropped to generational lows.
Right, the crime stats again.
When violent crime is at a 30-year low and continuing to decline, many analysts found it challenging to credibly argue that typical policing methods couldn't adequately maintain order. This observed discrepancy strongly suggests that the motivation may not have been solely public safety. Instead, it might be interpreted by some as a calculated display of federal authority, perhaps intended for a specific political audience.
And the Los Angeles situation, with federal forces, including Marines, being deployed to respond to protests, also seems to fit this pattern, doesn't it? Military response to protests.
It does. The deployment of military assets, including active-duty U.S. Marines for what were fundamentally street protests, and doing so explicitly over the objections of local authorities, prompts questions about the proportionality of the response. This suggests that the aim might have been as much about asserting presidential power and federal supremacy as it was about quelling any actual violence.
Like Newsom's spectacle comment.
Exactly. California officials were clear on this point. Local law enforcement was not reported to be overwhelmed or unable to handle the situation. They contended that the federal intervention was aimed at creating a political spectacle, which further underscores the idea of a response that critics argued extended beyond the immediate threat.
The second area of examination involves the targets of enforcement. When might public order policies become subject to scrutiny based on who they are targeting? How does selectivity play a role?
Public order policies can become subject to scrutiny and potentially an indicator of a shift in governance approach when they focus not on all threats equally or impartially, but specifically on those groups or perceived threats that are, in observers' views, aligned with the government's stated political concerns or narratives.
So who was being targeted in 2025?
In 2025, a pattern was observed where federal actions consistently focused on immigrant communities and cities led by Democratic officials. President Trump's rhetoric frequently singled out cities with large minority populations and Democratic leaders, such as Los Angeles, D.C., Chicago, and Baltimore.
So the groups deemed dangerous or requiring intervention appear to align with the president's political messaging and targets.
That's a key observation made by many analysts. The groups often characterized as dangerous in official statements, such as illegal immigrants, gangs, and insurrectionists, appear to align with the president's established political talking points and strategies.
While other areas facing crises didn't see the same response.
By contrast, predominantly Republican or rural areas, which may have their own distinct public safety challenges, like opioid crises or militia activity, typically did not experience similar federal military deployments. This observed selectivity led many to suggest that political considerations might play a role beyond universal public safety.
And immigration in particular seems to be a significant area where these dynamics play out. How is it used as a tool here?
Immigration is indeed an area where these dynamics are prominent. By broadly enforcing immigration laws, even against those without serious criminal conduct beyond their immigration status, and by generating a sense of concern within immigrant communities, some analysts suggest the administration cultivates a narrative of an internal threat.
An enemy within.
This narrative, in turn, can serve to mobilize a political base while potentially marginalizing communities that are perceived as less supportive of the ruling government. A critical point arises when IC operations begin to include longtime residents or individuals who are outspoken critics on what might be considered technical immigration violations.
Targeting dissenters via immigration law.
That's the concern. This moves beyond typical law enforcement and raises questions about whether state power is being used to address dissent or to create a more compliant population.
Okay, about 25 minutes in now, let's do another micro recap. We've pinpointed two critical indicators of public order transforming into what critics call government preservation. First, a disproportionate response that far exceeds the actual threat.
Like troops despite low crime.
And second, the selective targeting of specific groups or political opponents.
Such as focusing on immigrant communities or Democratic cities.
This illustrates a potential shift from broad public safety concerns to a more centralized and politically influenced form of control.
The third potential indicator of this shift is what can be described as the erosion of institutional checks. In a healthy, functioning democracy, public safety efforts, even robust ones, typically operate strictly within legal and constitutional bounds.
Meaning courts, local cooperation, press.
Exactly. This includes a robust system of court review, cooperation with local governments in policing matters, and scrutiny from an independent press. By contrast, actions that critics characterize as aimed at government preservation often involve the deliberate circumvention or bypassing of these essential checks and balances.
Can you give us specific examples of this observed erosion? How are checks being bypassed?
Certainly. The effective elimination of bond hearings for certain detainees, as outlined in the ICE memo, is a prime example. It reportedly removes a layer of judicial oversight from the process of detention, allowing individuals to be held solely at executive discretion without an independent review of their case or the necessity of continued confinement.
Taking the judge out of the equation for release.
Essentially. Similarly, the federalization of D.C.'s police department bypassed local elected leadership entirely, circumventing traditional democratic accountability at the municipal level.
Cutting out the mayor and council.
Furthermore, the public statements by some administration officials that appear to express skepticism toward court oversight, arguing that once the president declares an emergency, his decisions should be beyond judicial review, are also noteworthy.
Implying executive power trumps judicial review in emergencies.
That interpretation suggests a perspective where executive power might be viewed as not necessarily constrained by the judiciary, which some analysts interpret as shifting the balance towards greater executive authority. A smaller but illustrative indication is the consistent lack of transparency. When agencies like the Department of Homeland Security were asked for comment on the new no-bond policy, they did not respond, an observation that for some indicates a broader pattern of limited transparency accompanying these actions.
So what does this all imply? When can we discern that public order measures might be shifting towards what critics describe as government preservation? How do we know when that line is crossed?
In essence, public order measures may be seen to shift toward government preservation when the state's enforcement actions appear to serve primarily to protect the ruling power's position and maintain its control, rather than to exclusively ensure the public's broad rights and safety.
Protecting the ruler, not just the ruled.
The discrepancy between the official narrative and the observable reality is often a key indicator. If crime rates are declining but state-sponsored enforcement measures are intensifying, it prompts questions about the underlying motivations.
The mismatch again.
Yes. If protests, even contentious ones, are met not with dialogue or measured policing, but with federal agents and rhetoric that frames opponents as threats or traitors, it raises questions about whether the focus is on maintaining genuine order or on addressing dissent.
This analysis certainly compels us to engage in a consistent analytical review, doesn't it?
Yeah.
Constantly asking why.
It does.
Yeah.
Evaluating governance requires a continuous analytical approach from its citizens. Are the actions being taken truly for the people's benefit and well-being, or are they primarily perceived as serving the government's self-preservation and the consolidation of its power? This is a critical distinction for ongoing analysis.
Okay, let's consolidate our understanding and capture the key terms from this crucial section. Time for our end-of-chapter mega recap on regime preservation.
Recap. The potential shift from public order to government preservation is indicated by responses to perceived threats that critics argue are disproportionate, the selective targeting of political opponents or marginalized groups, and a systematic erosion of institutional checks and balances. When power appears to consolidate and accountability diminishes, it prompts questions about the state of democracy.
And the key flashcard terms for this section. Disproportionate response.
Measures exceeding the actual threat, like the heavy military presence in D.C. despite low crime.
Selective targeting.
Focusing enforcement on groups tied to the regime's political narrative, like immigrants or democratic cities, rather than applying it evenly.
Erosion of checks.
Bypassing judicial review, like the no-bond policy, or sidelining local democratic control, like the D.C. police takeover.
And the core concept, government preservation.
When coercive state actions primarily serve to protect the ruling power's position, potentially at the expense of broader public safety or rights.
To truly deepen our understanding of the points we've discussed, let's systematically break down the claims versus facts for each major justification offered by the administration. This will help us reinforce how these actions relate to objective reality. Let's start with Claim 1, the narrative of a crime wave in the cities demanding federal intervention. How was that sold?
This narrative was presented with considerable urgency and strong language. President Trump consistently described D.C. as experiencing significant lawlessness, using powerful rhetoric about violent criminals and cities being overtaken by disorder. This was intended to create a sense of crisis that would justify extraordinary federal intervention.
But what was the reality on the ground according to the available data at the time? We touched on this, but let's be explicit.
The reality, as evidenced by objective data, presented a notable contrast to this narrative of surging urban crime. In Washington, D.C. specifically, violent crime had reportedly fallen by 35% in 2024, reaching its lowest levels in over 30 years.
Lowest in 30 years.
Furthermore, it continued its decline, falling another 26% in the first half of 2025. Even Chicago, a city also specifically named and discussed for potential federal intervention by the administration, likewise saw notable crime declines in the first half of 2025.
So the trend was down, not up.
Correct. Local officials in D.C. and elsewhere publicly suggested that the administration was selectively presenting or emphasizing crime statistics for political effect. The dramatic language about violent gangs was, for some, rhetoric consistent with a political campaign rather than a reflection of an immediate emergency status on the ground.
So the interpretation here by many is that the crime wave argument served as a pretext, a justification after the fact almost.
Precisely. The crime wave argument was widely interpreted as serving as a basis for federal action that, critics argued, harbored other, more politically oriented objectives, such as demonstrating executive power and challenging the authority of local leaders who were political opponents. The available facts did not appear to fully support the presented narrative of an escalating crime crisis.
Let's move to Claim 2, the idea that a riotous insurrection in Los Angeles necessitated troops. How was this narrative developed by the administration? What was the specific language?
The administration and its allies heavily utilized this narrative. They characterized the anti-IC protests in LA as a significant threat, an insurrection against lawful authority that local police were purportedly unable to manage. Department of Homeland Security officials spoke of 1,000 rioters and painted vivid scenes of widespread chaos, aiming to depict a situation spiraling out of control and demanding military-level intervention.
1,000 rioters.
Yeah.
Insurrection. Very strong claims. And the reality, as we discussed earlier, appeared to be significantly different when examined closely. What did the evidence actually show?
The reality, as documented by reports and testimony, was quite different. While some unrest did occur, including tossed objects and isolated acts of vandalism evidence that emerged, particularly from federal intelligence testimony by General Sherman, showed little major violence around the immigration raids.
Little major violence.
Much of the protest activity was reportedly localized and relatively small, numbering in the dozens to a few hundred people, by most accounts. While the Los Angeles mayor, Karen Bass, did impose a curfew at one point, city leadership was managing the situation and reportedly strongly objected to the militarized response. Governor Newsom explicitly stated that President Trump deployed forces not because there is a shortage of law enforcement, but because they want a spectacle.
So the deployment of Marines and thousands of Guard troops was seen by many as highly disproportionate, to the point of being initially questioned by a federal judge.
That's correct. The use of Marines and thousands of Guard troops was widely viewed as highly disproportionate to the actual scale of the protests, so much so that a federal judge initially ruled it to be outside proper legal bounds. California's position was that the federal show of force was primarily about politics, not public safety. As Governor Newsom stated, "The president is not a king. We will press forward with our challenge to his authoritarian use of U.S. military against our citizens."
So framing it explicitly as authoritarian.
This framing suggests that the deployment was an act critics attributed to a desire for government preservation, utilizing troops to send a message to dissenters and to rally a political base rather than to address an actual insurrection, which the situation was reportedly not.
Next, Claim 3, that a border emergency justifies extreme detention and deportation measures. This has been a consistent message from the administration, hasn't it? The border is always in crisis.
It has been a central component of their public messaging. The administration consistently asserted that a crisis at the southern border described as a flood of illegal immigration required unprecedented tough new laws, the construction of extensive detention facilities, and the curtailment of due process rights for migrants. This was presented as an urgent and necessary response to an overwhelming threat.
But again, how does this narrative compare against the actual border crossing numbers at the time, the data we mentioned earlier?
The reality, again, presented a direct contrast to the narrative. Unauthorized border crossings reportedly hit record lows in 2025 after President Trump took office. Far from an unmanageable surge, the inflow of migrants significantly decreased.
Record lows.
Furthermore, Congress's own spending bill analysis, as we noted, indicates that the expanded detention capacity for 100,000 individuals notably exceeds historical detainee counts. Critics logically questioned, if fewer people are arriving, why is there a need to detain so many more?
Good question. What's the inferred answer?
The answer, for many observers, appeared to be that the administration was broadening its enforcement net, domestically utilizing ICE in the interior to apprehend long-standing residents, asylum seekers, and even legal residents on technical violations. This strongly suggests that the emergency was, for some, amplified to facilitate a pre-existing agenda of aggressive removals and to visibly demonstrate the administration's resolve.
And this included measures that appeared to be more punitive rather than directly addressing humanitarian issues, like those asylum fees.
Exactly. Measures such as charging asylum seekers higher fees or limiting avenues for release did not, critics argued, directly address humanitarian concerns at shelters or facilitate the management of legitimate asylum claims. Instead, they were often interpreted as punitive measures aimed at deterrence and expediting removals, which raised concerns about adherence to international obligations concerning refugees.
So the mismatch is key here, too.
In short, many observed a mismatch between the rhetoric and the numbers, a characteristic, some argued, of policy driven by political objectives rather than objective facts on the ground or genuine humanitarian needs.
Finally, Claim 4, that the administration is primarily targeting criminals, such as gang members, looters, and traffickers, not ordinary people. This is a common way to justify broad enforcement actions, isn't it? Focusing on the bad guys.
It is, and it can be a rhetorically effective strategy. Federal officials frequently frame their actions as focusing on dangerous individuals, MS-13 gang members, violent felons, drug smugglers. When deploying the Guard to D.C., President Trump spoke about violent gangs, and IC raids in L.A. were ostensibly about apprehending individuals with criminal associations. This approach aims to assure the public that the actions are legitimate and directed at identifiable threats.
But the reality, again, appears to broaden that definition of criminal quite significantly in practice. Who actually gets caught in the net?
It does. While some individuals with criminal backgrounds are indeed apprehended, the operational scope has reportedly included thousands of nonviolent immigrants whose primary offense was unauthorized presence, and even some individuals with legal status in the country.
Nonviolent immigrants, even legal residents swept up.
Yes. ICE's aggressive reported daily arrest quota and its expanded enforcement mandate suggest that collateral arrests, meaning people who are not the primary target or who have no serious criminal records, can occur. The reported removal of bond hearings means that even a low-level offender or an asylum seeker with a credible case could be detained for extended periods without an opportunity for release or judicial review. This approach, for some, suggests that a minor immigration violation or a traffic infraction by an undocumented person could lead to the same severe response as a more serious crime.
So the overarching objective might be seen as volume and visible assertiveness rather than a more targeted reduction of specific threats. It's about the numbers.
That's a key observation by many. Such a broad approach suggests that the primary objective might be high volume and a public display of assertiveness, rather than a carefully calibrated public safety strategy. Additionally, a critical component is that local consent was often absent. In California, local and state officials reportedly objected vehemently to how ICE and federal troops operated, implying that the communities themselves did not perceive the need for such extensive federal measures.
Which is different from community policing.
Exactly. A genuine public safety campaign typically works with communities to identify and address threats. Actions perceived as primarily related to government preservation, by contrast, might be imposed on communities without their full consent, potentially exacerbating existing concerns and distrust.
So if we look at the overall conclusion for all these claims versus reality, what analytical picture emerges? What does this comparison tell us?
By systematically juxtaposing the claims and the realities, it becomes evident that the narrative regarding a domestic enforcement focus is not, for many, alarmist. It is supported by concrete, verifiable discrepancies.
The gaps are real.
Crime was reportedly down, yet troops were deployed. Border crossings were at record lows, yet extensive detention facilities were being constructed. Protests were described as limited in scope, yet they were sometimes characterized as insurrection. These significant gaps suggest that factors beyond stated public safety goals might be driving policy, namely, a concentration of power and a systematic effort to assert federal control, sometimes under the guise of responding to emergencies that are, to a significant extent, debated or amplified.
Okay, let's consolidate our understanding and capture the key terms to conclude this section. Our final end-of-chapter mega recap.
We've systematically examined the core justifications for the recent federal actions by comparing them against objective data and expert testimony. The consistent mismatch between rhetoric and reality strongly suggests, for many analysts, that these public safety measures might serve as pretexts for broader political objectives. Consolidating power, asserting federal control over local autonomy, and influencing public perception, regardless of actual conditions on the ground.
And the key flashcard terms summarizing these discrepancies. Crime wave claim.
Directly challenged by DC's 30-year low crime rates and declines elsewhere.
Riotous insurrection claim.
Undermined by military intelligence showing low threat in LA.
Border emergency claim.
Contradicted by data showing record low unauthorized border crossings in 2025.
Targeting criminals claim.
Reportedly broadened in practice to include sweeping arrests of non-violent individuals and even legal residents.
And discrepancy.
The crucial recurring gap between the administration's stated goals and the actual verifiable outcomes, which points towards potential ulterior motives.
A crucial element of this focus on internal enforcement, and something we need to delve deeper into, is the transformation of icy immigration and customs enforcement into what critics describe as a more assertive domestic security force directly available to the executive. How did this expansion of IC connect with broader trends in executive power and potentially democratic principles? This seems central.
This is a critical area for understanding the current dynamics. There are several facets to how ICE's expanding role might contribute to executive power and shifts in democratic governance. The first is its increasing capacity to circumvent traditional due process and institutional checks.
And how is that happening? Specifically in terms of judicial oversight, how are they getting around the courts?
As we've already discussed, IC's new policies, such as the directive reportedly denying bond hearings for many in custody, appear to effectively remove a layer of judicial oversight from the process of executive detention.
Because immigration courts are part of the executive branch.
Exactly. It's important to remember that immigration courts operate under the Department of Justice, which is part of the executive branch, rather than being an independent judiciary. Critics argue the administration is utilizing this structural reality. By instructing IC attorneys and officers that entire categories of immigrants are categorically ineligible for release, the administration appears to sidestep the requirement for individualized judicial review,
leading to longer detentions without a judge's say.
This can lead to prolonged detention and ultimately deportation, without the kind of hearing that would typically allow for review of errors or alleged abuses.
So this raises significant constitutional questions regarding due process, doesn't it? The Fifth Amendment applies to persons, not just citizens.
It absolutely does. This approach is viewed by many legal scholars as potentially inconsistent with constitutional principles. The Fifth Amendment guarantees due process to persons, not just citizens. Lawsuits that are already being filed contend that indefinite detention without a hearing or without the possibility of bond violates this fundamental right.
And the power implication.
If the executive branch can unilaterally detain and deport people, even long-term U.S. residents or those with valid legal claims, without significant independent judicial review, it concentrates a notable amount of power in the president's hands. This power, critics argue, over individuals' freedom, exercised without independent court oversight, is a characteristic observed in authoritarian regimes.
The second facet is the potential for ICE to be utilized in ways that critics describe as targeting political or social enemies. How does this relate to potential shifts in democratic governance, using ICE against opponents?
A pattern observed in some instances of democratic backsliding involves the systematic use of state agencies to target groups that are perceived to oppose or challenge the leader or ruling party. Immigrants, particularly undocumented ones, are often viewed as vulnerable because they typically possess limited political power, especially lacking the right to vote, and can therefore be publicly characterized in ways that rally political support.
So the concern is ICE could be used against activists.
In the current scenario, there's a plausible concern among some analysts that ICE could be strategically utilized to target outspoken immigrant rights activists or even broader political adversaries under the pretext of immigration violations.
So, for example, what if a legal permanent resident is a vocal community organizer who is critical of the administration's policies? Could they be targeted?
Exactly. Consider that some individuals reportedly caught up in the LA raids were, in fact, legal permanent residents. If ICE agents operate with significant discretionary power, they might, for instance, detain a vocal community organizer on a technicality, say, a minor paperwork lapse or a past misdemeanor, potentially to remove them from the public sphere or to convey a message to their community.
Chilling dissent.
The more resources and latitude ICE possesses due to increased funding and fewer apparent legal constraints, the easier it might become to conduct operations that are perceived as having a political dimension. We've already seen hints of this through the rhetoric surrounding the LA protests, which, for some, characterized immigrant communities and their allies in negative terms, sometimes citing their display of foreign flags. It's a point of analysis to consider whether the government might utilize ICE to influence immigrant communities that are perceived to be politically unsupportive, potentially leading to a chilling effect on dissent.
Which erodes democratic norms about impartial law enforcement.
In a healthy democracy, law enforcement is generally expected to operate impartially, but when those lines blur, it represents a significant area of concern for democratic norms.
And then there's the expansion of executive-controlled manpower. This seems to be building what some describe as a nationwide federal enforcement force. More federal agents, less local control.
That's a very common description. By doubling ICE's personnel and empowering them to operate nationwide, even within so-called sanctuary jurisdictions that traditionally limit cooperation with federal immigration enforcement, the administration is indeed building a significant federally controlled enforcement presence that, critics argue, can notably bypass local authorities.
And pulling local police into it.
The July spending bill explicitly funds partnerships with state and local law enforcement, which some interpret as effectively integrating local police into aspects of ICE's mission. So if local leaders object, as many cities do, to cooperating with ICE on deportations, the federal government now has greater resources to potentially pressure or, in some cases, override them.
And this leads to what some analysts describe as a centralization of coercive power. More power in D.C., less locally.
In its most pronounced form, as we observed in D.C., President Trump assumed control over the local police. In other areas, the executive branch can now deploy federal agents, as happened in 2020's Operation Legend, and is reportedly occurring now, agents who answer directly to federal command.
Undermining community policing.
This, critics argue, directly challenges the tradition of localized, community-accountable policing and instead places greater power in the hands of the executive branch's chain of command. The centralization of coercive power, a characteristic observed in some authoritarian contexts, is, for many, incrementally advancing. ICE, Border Patrol, and even deputized guard units are being integrated into a broader network of forces under direct presidential control or strong influence, potentially available for domestic deployment in various capacities, resembling a centralized control system that can influence or override distributed networks of local law enforcement.
The fourth point is about lawfare against immigrants, using legal procedures as a tool and for public display. Explain lawfare in this context.
The term lawfare refers to the strategic utilization of law and legal procedures against an opponent. The ICE expansion, with its new powers and resources, can be seen as enabling a distinct form of lawfare against immigrant populations.
Through punitive measures.
Yes. Policies like fast-track deportations, the imposition of fees for asylum. The July law, for instance, reportedly imposes a first-ever $100 fee on asylum applications and substantial work permit fees. And tightened asylum rules all contribute to a single objective: expediting removals and deterring new applicants.
And this also appears to serve a political purpose. How does it play politically?
Absolutely. The administration frequently highlights these actions at political rallies, reportedly using the outcomes of these actions as tangible evidence of its resolve to its base. From an analytical perspective on democratic governance, this serves two crucial functions. First, it can mobilize a political base by emphasizing nationalistic sentiments, thereby cultivating an in-group versus out-group dynamic that can be observed in some authoritarian contexts to solidify support.
Us versus them.
Exactly. Second, and perhaps more subtly, it conveys a broader message that the executive can and will prioritize its goals over typical humanitarian considerations and independent review, regardless of legal or ethical considerations. In other words, it may acclimatize the public to a more assertive and unilateral style of governance, which can then potentially be extended to other areas and other groups once such precedents are established.
Finally, what about the potential for actions that appear to challenge judicial orders and oversight? This seems like a significant challenge to the rule of law. Is the administration pushing back against court rulings?
This represents a critical point in discussions of democratic governance, when the executive branch's actions are perceived as challenging or disregarding court orders. While there has not yet been outright defiance, though President Trump has publicly expressed strong views on judges who rule against him, the administration's strategy has involved implementing policies that critics argue are clearly in tension with existing consent decrees or established rulings.
Like the bond hearing policy versus previous court decisions.
For example, past Supreme Court decisions, such as Zadvydas v. Davis, require bond hearings for certain immigrants after 6 months of detention. The new ICE memo, critics contend, appears to disregard these precedents, pushing the boundaries of executive power.
So the analytical question is, if courts push back, what happens next? Will they comply?
That's the critical juncture. If the courts push back forcefully, the question becomes whether the administration will comply or whether it will seek loopholes or even challenge judicial authority directly. A democracy is generally considered healthy only as long as court orders are consistently obeyed and respected by all branches of government. A leadership that appears willing to test those limits by implementing policies that are widely seen as in tension with existing legal frameworks is, for some analysts, signaling that maintaining its power or enacting its agenda might take precedence over the fundamental rule of law itself. This, for many, is a significant area of concern.
So what does this all signify when we synthesize ICE's dramatically expanding role? What's the bottom line here?
ICE's significant expansion and its assertive new mandate are central to how the executive branch is, in the view of many, consolidating power domestically. By systematically detaining and, in some cases, deporting people with what critics describe as inadequate due process, the administration is not merely impacting individual rights. It is also, in the view of some, setting a precedent that the executive can act unilaterally in what might be seen as an almost judge and jury capacity, bypassing elements of the traditional legal system.
So it's about more than just immigration enforcement.
This observed erosion of checks, the potential targeting of marginalized groups and perceived political adversaries, and the empowerment of a significant federal enforcement agent corps are all characteristics that some analysts point to when discussing shifts in democratic governance. What's particularly salient here is that while immigrants are currently the primary focus, historical analysis often suggests that once such enforcement mechanisms and expanded powers are put into place, they can, and sometimes are, subsequently utilized against other groups deemed undesirable or unsupportive of the government.
The slippery slope argument.
It's a historical observation. The traditional bulwarks of democracy, independent courts, decentralized power, and the robust protection of minority rights are, in the view of some, being notably influenced in the name of expediency and a perceived, often debated, need for security.
Okay, let's consolidate our understanding and capture the key terms for this final analytical section on ICE's role. Our last end-of-chapter mega recap.
ICE's transformation into a significantly empowered domestic enforcement force is a critical area for analyzing executive power and potential shifts in democratic governance. This includes observed trends in bypassing due process, the potential for targeting perceived adversaries, expanding federal personnel to influence or override local authority, utilizing legal mechanisms for political ends, and actions that challenge judicial oversight. These dynamics collectively raise questions about the strength of democratic bulwarks against executive power.
And the key flashcard terms for this section. ICE transformation.
Shifting from managed enforcement to potentially an instrument of mass detention removal at executive discretion.
Circumventing due process.
Like denying bond hearings, bypassing individualized judicial review.
Targeting enemies.
The concern ICE could be used against political or social opponents via immigration law.
Executive-controlled manpower.
Doubling ICE personnel, enabling nationwide ops, potentially overriding local police, centralizing force.
Lawfare.
Using immigration law, fees, rules, raids, strategically for political effect or deterrence.
And challenging oversight.
Implementing policies potentially conflicting with court rulings, testing the limits of judicial review.
So as we bring this deep dive to a close, let's connect the dots. In earlier deep dives in this series, we've established foundational facts and patterns related to democratic governance, how leaders operate within or challenge electoral processes, interact with media, and engage with institutional norms. Here, in this deep dive, we've illuminated the crucial domestic enforcement dimension of these dynamics, how the state uses force internally.
This is a critical point for you to consider and analyze. When a government's actions involve systematically utilizing police and federal forces domestically, and when immigration law is employed as a targeted tool that critics argue aims to reshape the domestic political landscape by influencing or removing specific populations, it prompts questions about the trajectory of liberal democracy. This isn't merely a theoretical exercise, it's a practical manifestation of policy choices.
A crucial analytical question that remains is whether institutional and public responses will be sufficient to navigate these trends. The judiciary's role is incredibly critical in interpreting and upholding legal frameworks, as are the actions of state and local officials who maintain their roles in response to federal initiatives. Their engagement provides an important point of analysis. Will the checks hold?
Also essential is your informed awareness. If citizens can discern when public safety rhetoric is utilized in ways that critics argue are less about immediate safety and more about maintaining a specific leadership's position, they can then respond through organized engagement, advocacy, and participation in the electoral process. Informed discernment is a vital element in a robust democracy, being able to see behind the curtain, so to speak.
Otherwise, today's emergency measures, often justified by perceived threats, may, in some analyses, become tomorrow's established reality, a system where the line between protecting the public and operating for government interests might become less distinct.
That's the concern, that the exception becomes the rule.
This is not merely an academic exercise, but an invitation for active, informed engagement with the foundational principles of a free society.
The facts we've meticulously analyzed today compel us to think deeply and analytically about the structural elements that underpin democracy. As you continue your own intellectual journey, consider what other historical or contemporary examples illuminate this delicate balance between security and liberty, and what specific role informed citizens like you can play in understanding and engaging with these essential principles.